Welcome back to the Dershow. You may notice I'm wearing a hat. It says Free Iran. I spoke today at a demonstration in front of the United Nations on behalf of the Iranian majority, the people of Iran, who don't like the mullahs and don't want to be ruled by them and want to see regime change. And I spoke in favor of regime change, in favor of um, allowing the people of Iran to vote for who they want to see as their leader. And of course, this afternoon, the president of Iran spoke at the United Nations General Assembly, and he blamed everything in the world on Israel. Of course, Iran has nothing to do with it. Yeah, they're sponsoring terrorism by Hezbollah, they're sponsoring terrorism by Hamas, they're sponsoring terrorism by the Houthis, they're sponsoring warfare and genocide in Sudan, but Iran, we had nothing to do with anything. It's all the Israelis' fault. Those Jews, you can't trust them doing anything. So I spoke against Iran. I didn't speak about Israel. I spoke generally about Iran and the Iranian people. I'm hoping, I wish that a year from now we had another demonstration in front of the UN with the elected leader of Iran speaking instead of the person who took over in a coup. And there's never been an election in Iran. And if there were, the current mullahs would never be allowed to rule the country. Also, an update on Israel. Israel has been ferociously attacking Hezbollah terrorists, as they should be, and they're killing terrorist leaders and terrorists. Now, of course, there are going to be some civilian casualties, but Israel is the only country in the world that warns people that they're going to attack and gives them 2 hours to get out of their homes. What do you expect a country to do when their intelligence shows that a particular home looks like a home, it has a living room and a kitchen and a bathroom and a bedroom and a basement and a garage, but it's used to launch rockets. The garage is used to launch rockets, or the basement is used to hold rockets that are then launched. Of course, Israel has the right to attack and destroy those rockets, and they warn the people. They're not innocent civilians. They know their house is being used, but they're still warned, and they get out. But inevitably, there are some people who will die. We have no idea how many civilians compared to how many terrorists and combatants have been killed. The ratio in all of Israel's wars have been better than the ratio in any other wars in history. That is, fewer civilians compared to combatants have been killed by the Israeli armies than any country in history, including, unfortunately, the United States and Iraq and Afghanistan and other places, and certainly NATO, and certainly in the Second World War, where we had like 100-to-1 civilian casualties to combatants in Hiroshima. Of course, it was thousands and thousands to one, but in Dresden, it was hundreds to one. And in other parts of the war, it was hundreds or dozens to one. In Israel, they've managed to reduce it to approximately 2-to-1. In most places in Gaza, it's a little less than 2-to-1. That is, for every combatant killed, about 1.5 civilians are killed. And during the effort to try to kill the people who were, or wound the people who were holding Hezbollah, communication devices, the ratio was much, much better than that. A tiny fraction of those killed were civilians. The vast majority of them were combatants who were actively involved in making a terrorist war on Israel. All right, now we switch our subject, a very big switch, to P Diddy. Let me make a confession. I don't know P Diddy. I couldn't recognize any of his songs. I occasionally like a rap song. It's not my genre. I much prefer Brahms, but I've heard some rap songs that I like, and I like the beat, etc. But I don't know very much about P Diddy, but I know a lot about bail. And I know a lot about the Constitution. And I know a lot about unfairness when I see it. Again, I don't know whether P Diddy is guilty or innocent. The evidence seems pretty strong against him. And if there is a trial, he may be convicted, maybe not. Who knows? People are acquitted. O.J. Simpson, with a lot of evidence against them. O.J. Simpson was held in jail pending trial. That's a problem. The Constitution provides in the Eighth Amendment for bail. It doesn't specify when it should be granted and when it shouldn't be granted. It says excessive bail shall not be required. And at the time of the framing, bail was not allowed in capital cases. And a lot of cases were capital cases back then. But today, there are very few capital cases. And the question is, who gets bail? So there are three possible criteria. Two of them are legitimate, and one of them is illegitimate. Legitimate criteria. Is the guy going to run away? That's a legitimate criteria. If the court feels, based on evidence and satisfying a standard, whether it be preponderance of the evidence or clear and convincing evidence, that this guy's not going to show up at trial, he's going to run away, that's a good basis for denying release. Question, should he be put in jail, or should he be required to stay home with ankle monitors, maybe even guards at his door? But he shouldn't be allowed to just roam freely if there's very substantial evidence that he might flee. The other legitimate criteria is, will he commit crimes while out on bail? You notice I didn't say will he commit another crime, because there's a presumption of innocence about the first crime. But if there is overwhelming evidence, for example, in the Rauch case, he wrote a note and he offered money saying, I didn't kill the president, but if anybody does it, I'll give him $150,000. Pretty darn good evidence that he might do it again. There's a precedent in American history on this, though. A case of Richard Lawrence, interesting case. I think I've talked about it before. 1832, the first presidential assassination attempt. Richard Lawrence walked up to President Andrew Johnson, very controversial president, had two loaded guns that worked perfectly when tested afterward. Two loaded guns, walked right up to the president. He was coming out of the Capitol. He had just finished a meeting. He was surrounded by his cabinet witnesses, no doubt about what happened. And Richard Lawrence pulled the first trigger. It didn't fire. He aimed the gun at the president's heart, and he pulled the second trigger, and it didn't fire. Then he was surrounded by cabinet officials and arrested and taken away. They then tested the guns, and the guns were perfect, but apparently it was a wet day. And in those days, if there was a lot of water in the atmosphere, it could affect the firing mechanisms of the gun. So by complete fortuity, Andrew Jackson was spared death by Richard Lawrence. So Richard Lawrence was prosecuted. He was prosecuted by an interesting man. You may have heard of him. He was a part-time songwriter, a poet. His name was Francis Scott Key. He wrote the national anthem, "O Say Can You See." Wrote it as a poem while he was observing the battle in the War of 1812. But he was a full-time prosecutor. He was the United States Attorney for the District of Columbia, and he prosecuted Richard Lawrence. And the case came before a very famous judge, Judge Cranch, one of the earliest great judges in American history. And the first question was whether or not Richard Lawrence gets bail. And you think, oh my God, how can you get bail? He tried to kill the president. The judge ruled he was entitled to bail. The judge ruled that there was no evidence that he would flee, and there was no evidence that he would do it again. But there was evidence that he was mentally ill. And so although the judge ruled that he would be entitled to be free pending trial, the judge also ruled that he could be committed to a mental hospital based on his mental illness. And ultimately, the case was decided on an insanity defense, and he spent the rest of his life locked up in St. Elizabeth's Hospital in Washington, D.C. But it's an interesting precedent. It shows that early in American history, there was a strong presumption in favor of a person being free on bail. So what's the third criteria? The third criteria is the one, obviously, that's operating in the P Diddy case. Everybody thinks he's guilty. If he's guilty, and he'll be found guilty, might as well put him in jail now. He'll get credit for the time he's in jail. So if he gets like 20 years, it'll be 20 years minus 6 months. The problem is we have a presumption of innocence. Now, what does the presumption of innocence mean? It could mean two things. It could mean we, the public and judges, must presume that anybody arrested is innocent until he's proved guilty. That's just not realistic in light of what we know in America, unlike in China and in Iran and other places, Russia. The vast majority of people who are brought to trial for serious crimes are in fact guilty. I know most of my clients who have been brought to trial and convicted have been guilty. Some have been innocent. Sometimes I don't know the difference, but Most have been guilty, and thank God for that. You wouldn't want to live in a system where the majority of people brought to trial are innocent. So how should the court deal with a situation where, look, this guy looks guilty. Look at the evidence. My God, look at that videotape of him kicking and beating up his former girlfriend. Oh, we don't like him. He's probably guilty. He'd probably be found guilty. But there hasn't been a trial yet. And there can't be a trial. Certainly for many months, you can't bring a person to trial right away. He has a right to prepare a defense. So what do we do with him in the meantime? It's easy if he's going to flee. There's no evidence that that P Diddy would flee. If he was going to flee, he would have fled earlier. He knew he was going to get indicted. It was no secret. He traveled to New York to get indicted and to get arrested and to get, taken in front of the judge. So if he wanted to run away, he has private planes, he has a fortune of money. He could have, in the months prior to that, when he wasn't being observed so closely, he could have probably flown his private plane to some country that doesn't have an extradition treaty, or a country that doesn't have an extradition treaty that covers sex offenses. France, for example. Don't know whether these crimes would be covered exactly, but France in general, Roman Polanski has been extradited by the United States, and France won't send him, although he was charged with having underage sex with a 14-year-old who allegedly he drugged, and yet France allows him to live the life of Riley. He just luxurious. I know when my son and I went to Paris for the opening of our movie Reversal of Fortune, which he produced, and it was based on my book. Who came to the opening? Roman Polanski. And he didn't like the way it was portrayed. He didn't think it was done with enough dignity. But we spoke to him, and then I actually represented him briefly. But Bo Diddy didn't go to France, and he didn't go to other places where he would have been welcomed with his money. Money buys a lot. So I don't think he's a flight risk. And if he were a flight risk, it's easy. You make him stay in a New York apartment. You make him wear an ankle bracelet. The ankle bracelet has, a 1,000-foot radius. If he goes beyond the radius, he's immediately apprehended and put in jail. Or if you think that's not good enough, you can require him to pay for his own armed guards. And the armed guards have to stand approved by the government, by the Marshal Service. And they have to stand in front of all entrances and exits to the apartment. I've had that happen with clients of mine. In fact, I got a court to reverse the refusal to do that. It was Judge Sotomayor when she was sitting as a circuit court judge before she went on the Supreme Court. She ruled in favor of my client and allowed him to stay out in home arrest with armed guards at his house. Some judges won't do that because they say, well, only some people can afford to have armed guards. But, the equal protection doesn't mean everybody gets reduced to the lowest common denominator. It means you try to bring everybody up to the best. And if people can't afford it, hey, they can't afford Harvard either, and they can't afford the best medical care either. That's what free market society does. But you don't deny a person who has the ability to have armed guards prevent him from fleeing. So I don't think there's any justification whatsoever for keeping P. Diddy in jail, in a house of detention, which is really a hellhole, you have to tell you. It's much worse than prison. Jail is much worse than prison. Prison has outdoors, you can work, you can play basketball. Jail is just, rat-infested cells with horrible food, and you're with people from the worst kinds of crimes, murderers and rapists and such. So, being in jail pending trial is horrible, and it should never be required unless the person really is very likely to flee or likely to commit crimes while out on bail. But it should not be a permissible basis that we think you're guilty. Look, we look at the evidence. We believe what we read in the newspapers. We believe CNN. We believe the New York Times. And on that basis, we're going to put you in jail. If you read what you believe in the media, you think that Donald Trump is guilty of crimes, which I'm sure he will not be found guilty of when the evidence comes in. Or if he were to be found, like in New York, it would be reversed on appeal because there was no crime at all in New York. But, he got bail pending appeal, but others have not. And I think the presumption ought to be very clearly in favor of pretrial release, not in favor of pretrial detention, because it really does reverse the presumption. Now, people argue the presumption of innocence has nothing to do with what the courts or what the judges, how they treat somebody, or how we treat somebody who's been arrested. Presumption of innocence only has to do with the jury instruction. The jury is told that just because there's been an indictment, you shouldn't presume that he's guilty. You should presume he's innocent until and unless you've heard sufficient evidence to conclude beyond a reasonable doubt that he's guilty. That's a narrow interpretation of the presumption of innocence. The vast majority of Americans understand the presumption of innocence in the broader sense that as an American citizen, merely being arrested doesn't change your status. Obviously, in the case of Rao, we now have a confession from him, a written statement saying, I was trying to kill the president, I failed. I'm going to give $150,000 to anybody else who succeeds. He's obviously guilty of something, as I argued yesterday. Probably not attempted murder. We'll get to that in the questions and the letters, because a lot of people disagreed with me. But the issue is whether or not you're entitled to treat him as guilty before he's found guilty by a jury. And I think the answer to that should generally be no. People should not be able to be tried by the media, even when the media is overwhelmingly against him, as it is in P Diddy's case. And even there might be videotapes. Now, the videotape doesn't show he's guilty of the charges that he's facing. It shows that he did some terrible things, but not necessarily relevant to the case at hand. His defense is going to be largely that the sexual activities were consensual, and often those are matters of degree and matters of interpretation. And we'll see. We'll see what the evidence is. We'll see what the corroboration is. We'll see what the motivations of the witnesses may be. Are they seeking money, compensation? We'll wait and see. That's why we have juries, to evaluate the evidence on both sides. But it's not the role of the judge without evidence, because the judge doesn't hear the evidence at a pretrial hearing. He may hear a smattering of evidence. He may see some testimony, get some testimony, but not enough to know whether the person is guilty or innocent. So a judge should not be entitled to put somebody in jail pending trial just because the judge believes that he probably will be convicted and probably is guilty, and there's probably enough evidence to convict him. We just don't know what juries would do. O.J. Simpson was held in jail pending trial for, I think it was over a year, and then he was found not guilty. You may think he was guilty, and that's your prerogative, but the jury didn't find him guilty. They didn't find him innocent. They found the government had failed to prove the elements of the crime beyond a reasonable doubt because of questions, scientific questions, about the DNA, about evidence that was tampered with, whatever the reason. There are surprising results in criminal cases. I've been the beneficiary of many of those surprising results, because I've had a lot of my clients acquitted, sometimes at trial, sometimes on appeal. And in the Klaus von Bülow case, for example, the overwhelming belief was that he was guilty, but we managed to get him out on bail. I argued that case, and he was out on bail, and eventually he was acquitted, and he never spent a single day in jail in his life. And the jury found him not guilty. Had he been denied pretrial release, he would have spent years in jail. And where would he go to get those years back? That's the question. You can't get them back. If you are spending a year or two in jail, that's a percentage of your life that you haven't been able to live freely. And if it's based on flight, okay. If it's based on real evidence of likelihood of committing crimes, justified. But if it's based merely on the fact that you think he's probably guilty and will be found guilty, that's just not enough. Now, I know a lot of you out there will say, oh my God, it's so obvious. Oh, obvious that P Diddy is not really guilty, but he's terrible and he should be going to jail. But that's not the issue. The issue is the rule of law and the Eighth Amendment to the Constitution. And so we'll see, because Obviously, the denial of bail will be appealed. Generally, denial of bail appeals are lost. I've won a few of them, but they're generally lost. And so it's very likely that P. Diddy will spend time in jail. And then, of course, his defense lawyer has a difficult choice to make. Should he seek a speedy trial, which would get him out of jail sooner if he's acquitted? But if he seeks a speedy trial, he may reduce the chances of winning because there'll be less preparation. Obviously, the government has had years to prepare for this case, but so probably has P. Diddy's lawyers had time to prepare. But I think just theoretically, conceptually, the system is not supposed to confine people before they're convicted unless certain criteria are met. And it's my view that those criteria have not been met in the P. Diddy case. So we'll hear what you think when you send me the expected letters that I know I will get. Okay, got a lot of letters about my claim that it's not so clear that the defendant in the second attempted assassination case on President Trump is actually guilty of attempted assassination. So here are some of them. So is preparation to commit murder a crime? Well, it's not the crime of attempted murder. Preparation is not an attempt. It might be a bunch of other crimes. It might be illegal possession of a gun. It might be trespassing. If he does it with somebody else, it might be conspiracy. But simply planning to commit a crime is not a crime. And remember, planning is on a continuum. You get the idea. Oh, gee, it might be nice to rob that bank. Then you go out and you check on the timing of when the bank opens, when it closes, how many guards there are. If two people do it, that's all a crime because it's an overt act. And that's enough for a conspiracy. But if it's one person, so I'm planning, thinking about it. Maybe I'll do it, maybe I won't. Go out, check the bank. Looks like a pretty good place to rob. I think I'll go. I go and I buy a mask. None of that's yet a crime. You have to go into the bank, and or you have to be caught about to go into the bank with your gun or with whatever the preparation is. And then it becomes very much a matter of degree. So the question, is preparation to commit a crime? The answer is it's not the crime of attempt. Okay. Oh, come on, Dersh. I understand attempted assassination can be nuanced, but you could have at least addressed the situation where the defendant literally writes an open letter stating this was an assassination attempt. Yeah, I didn't know that at the time of the first show. I now know it. And of course, that's relevant evidence, but it's not enough. If you write a letter saying, I am planning to commit a crime, I'm about to commit a crime, I hope to commit the crime, I expect to commit the crime, that's not enough for attempted murder. Maybe it should be. But under the current rules, that still is mere preparation. And mere preparation is not enough for attempted murder in most jurisdictions. There are some jurisdictions now under the model penal code and other changes that make it a little easier to convict for attempt. But still, in the case under advisement, even under the model penal code, it's questionable. It's questionable. In some jurisdictions, you have to take a substantial step toward commission of the crime. Well, he did. He took a substantial step. He hid in the bushes. He put his gun. That's a substantial step. So under that criteria, it would be enough. Under other criteria, it would not be enough. And then, I got a bunch of letters saying, wouldn't it be fun to have been in my class when this issue was debated with all the cases that we've talked about? And then one said, I think it would be fun to see Alan and Ted Cruz debate some of these issues. Well, you missed your opportunity. We did debate those issues for a whole semester at Harvard Law School. He was my student, and he was always raising his hand. And I don't remember specifically whether we ever debated attempt law, but we certainly debated a lot of other issues. And students would love the debates between me and Cruz. They didn't love Cruz so much because, they thought he was a know-it-all, but he was a know-it-all. I mean, he knew a lot and was a great debater and a great arguer. And one of the reasons that I've said he was one of my best students is he challenged me all the time. And I love students who challenge me. I hate students who just say, well, if the professor says it, it must be true. Professor Dershowitz, thank you for the enlightening segment. Wish I had been your student in law school. Criminals can change their mind. So in the golf course, just as the official into meddling Secret Service agent shot in the direction of the red barrel, the rifle barrel, what if he had changed his mind and was leaving? Intent is lacking. Conspiracy is another matter. Well, that's the argument that would be made. But there is a concept also in the law of attempts called, I don't want to get into the Latin, but in Latin it's locus penitente, the point at which you can still repent and change your mind and not be guilty of an attempt. So that's one of the issues that you study in criminal law. And, if he had been looking around and saw the president and said, I like the smile on his face. I was wrong about him. I'm going to change my mind and go back. And if there were a videotape of the whole thing, the question would be at that point, if he had changed his mind, could he be charged? And I think the answer to that is pretty clearly no. Sir, you are most interesting in your explanation of murder cases. I wish your classes were on videotape. I would watch for hours and learn so much. Your students should be very successful if they learned how to think and act on what you taught them. I really enjoy your videos. Thank you, Professor Dershowitz. You are easy to understand. You articulate with common sense. Well, not easy to understand always, because the issues aren't easy to understand. I think one of the jobs of a lawyer is to be a translator, and that is to try to take complex issues and make them understandable to an average juror. And I try very hard to teach my students how to do that. All right, let's change the subject. I just watched the movie Route 60, narrated by David Friedman, the former U.S. ambassador to Israel, and Mike Pompeo, the former Secretary of State, both friends of mine. It was a biblical and visual documentary on Israel done before October 7th. Hope these guys are in Trump's White House again. So they're both friends of mine. I've seen the movie. I love the movie. It's fantastic. It's all about the relationship between biblical Israel and current day Israel, biblical Eretz Yisrael, Judea and Samaria, and current day Israel. And David Friedman does a phenomenal job, along with Mike Pompeo, of exploring the roots, Christian and Jewish and Muslim as well. One of the reasons that I am still thinking hard about not voting for Harris, but voting for Trump is because I'd love to see an administration which included David Friedman and Mike Pompeo. They are both great people, both great Americans, and would be incredible members of any administration. I wish we lived in an age where even if a Democrat was elected, they would be smart enough to appoint David Friedman and Mike Pompeo, but that's not the world in which we live in today. Back to Israel. Since the pager was a weapon of war utilized to organize an attack, it is a legal target of war. At least that's my understanding. Your understanding is 100% correct. And the former head of the CIA, who said the opposite, was just dead wrong. He doesn't understand that you are entitled to attack a communication mechanism and the person who was using it. How in the world would you argue otherwise? Just like arguing that since explosive materials, bullets, and other tools of war are in a factory, the factory that manufactures them cannot be attacked. Of course you can attack anything that produces war items that are used in war, and you can attack people who are used as terrorists in war, even if they're not acting as terrorists right then. So, the issue is a hard one. I wrote a piece. It's in today's Hill. You can access it. It's entitled "Why Israel's Use of Explosives in the Beepers and Radios is Entirely Legal," and it's an answer to my former colleague Michael Waltzer's article in the New York Times, which suggested that it was illegal, but it's completely legal. And read my article in the Hill. You can get it online, The Hill. It's a national media published in Washington, D.C., and I write for it from time to time. And I lay out all the arguments for proportionality and for the distinction between civilians and military people. So I am confident, I'm comfortable with the conclusion that what Israel did was right, and they shouldn't be deterred from doing it in the future by academics and by the United Nations, which is going to condemn them for it, and by others who are one-sided. What Israel did was absolutely right. If you think it wasn't write me a letter and I'll read it. Thanks. See you tomorrow.